Welcome to U.S. Immigration TV. Well, sometimes a person's child may be eligible for a visa under several different petitions, such as a direct petition under the F2A family category, which is minor child of an immigrant, or even as a derivative under the parent's family or employment-based petition. Well, the question is, which petition should they choose? In this video, I will discuss some of the factors to consider when deciding under which petition you should process your child. So make sure to watch this video until the end, and of course, like, share, and most importantly, subscribe to this channel so I know you're out there and you find these videos helpful. Also, very important, if you have any questions or issues on your case, you should consult with an attorney for a personal and individualized evaluation of your particular case. I mean, don't act on the basis of watching any YouTube video. See an attorney. Now, let's take a question from a parent that will serve as an example. So here's a letter that was sent to me. Dear Attorney Gurfinkel, I am a nurse and I was petitioned by a facility or a hospital. I received my visa at the U.S. Embassy and I arrived in the U.S. in 2022. I immediately filed petitions for my children in the F2A category. But I was heartbroken when I saw the October 2023 priority dates because they are now only processing cases with priority dates before February of 2019. That means it could now be more than 3 years before I could be reunited with my children in the U.S. Is there a faster way? And of course, by way of this letter, we're focusing on the October 2023 priority dates. If this is several months from now, perhaps the visa bulletin or the priority dates will change and the answer could be different. But for right now, we're using this particular example based on the October 2023 priority dates. So here's my analysis. Well, first, I know it is very disappointing for so many immigrants who had petitioned their spouses and their minor children in the F2A category because I know that category had been current for so many years, meaning visas were immediately available, but now it has retrogressed or moved backwards several years. That's because there's more people applying for that visa than there are visas available, supply and demand. Unfortunately, unless and until the priority date on your petition is current in the final action dates chart on the visa bulletin versus dates for filing, the applicant will not even be queued up for an interview, even if they are receiving letters from the NVC that they are documentarily qualified or documentarily complete. You would have to monitor the monthly visa bulletin and hope it moves forward and your priority date becomes current. Now, if the child is in the U.S., it's a little bit different and they're eligible for adjustment of status. They may be able to use the dates for filing chart on the visa bulletin to file for adjustment. But for purposes of this example and this question, I'm assuming that the child is outside the U.S. and will consular process at the embassy. Now, another possible avenue to explore for this particular parent is that if a person was petitioned by an employer, or in some family cases, the employer petition includes not only the worker, whether they are a nurse, a caregiver, housekeeper, accountant, bookkeeper, etc., but the petition also includes the worker's spouse and children under 21 years of age. In fact, you could have brought that child along with you when you immigrated under your employer's petition rather than leaving them behind. In fact, I often recommend that if your child is eligible for a visa, bring them into the U.S., let them get the green card, and if you want to send them back to finish school or whatever, send them back on a re-entry permit versus, oh, I'm just going to come first and let my kids finish school, because sometimes things come up. They could age out. You could have another COVID shutdown. However, even if you left your child behind, it could still be possible to reopen your employer's case and have your child follow to join you and obtain a green card as your derivative beneficiary under the employer's petition versus waiting years until your F2A family petition becomes current. Of course, it will depend on the priority date of your employer's petition for you, as the priority dates for employment-based petitions have also retrogressed. So it's important to know what that priority date is in relation to the visa bulletin. There may also be issues of whether your child can still be eligible if they are over 21 under the Child Status Protection Act. However, if the priority date on your employment-based petition is still current, then perhaps your children could be eligible to be processed for their immigrant visa right now as a derivative beneficiary under your employer's petition versus waiting for your F2A petition to become current. Now, if you have left behind family members in the Philippines or any other country, you may want to consult with an attorney who can evaluate your case and see if there are other ways or faster ways that your family can immigrate. With the retrogression of the priority dates, they create many additional years of waiting and delays, and perhaps there could be a faster way for your family member. I hope you have found this video informative and useful to you, or maybe somebody you know. That's the purpose of these videos, putting out information based on real life situations that I have encountered. Because if people are coming to me with consultations or issues, maybe you have the same question. That's why it's important. Make sure to like, share, but most importantly, subscribe to this channel. Because what I want to do is put out videos that perhaps take complex situations and try to simplify them so that they are understandable, remove some of the mystery for you so that you can perhaps find better and faster ways to be reunited with your family. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.